made no sense for Trump because it could have only hurt him.
Yeah, him talking causes pain to everybody.
Even now he's losing a lot of viewership and he's losing a lot of people at his rallies. His rallies have gotten really small because now all he does is he goes up there and he just whines about his court cases. And if you weren't following his court cases, you wouldn't have a clue what he was talking about. It's insane.
Yeah.
But Trump's now facing that whole situation where Colorado has their case, and it looks like the Supreme Court's going to take it on whether or not he can run for office under the 13th Amendment. I think it's Article 3 of the 13th Amendment. Not Article 3, Section 3, whatever it is. But here's Chris Hayes, and he had a Harvard lawyer on, and he wanted to, just his prediction on what he thinks is going to happen here. And I think this is really fascinating. So these cases are going to the Supreme Court soon.
Framing for what is being debated before us, what we're ruling on. And the question presented, they adopted is the one from Trump's cert petition. And it's a simple one. It said, did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? And the reason that's interesting is because the Colorado GOP, which also appealed, had much more sort of specific and technical questions presented. But it looks like the court is adopting the kind of broadest possible, which gives them any possible avenue to consider.
I think you're exactly right, Chris. They adopted a question that doesn't constrain them in any way. They are going to decide whether to affirm or reverse the Colorado Supreme Court. There are many
So I want to clarify that. So for those of you who don't know, so lower courts decide fact. The Supreme Court cannot decide what is or is not a fact, just technically speaking.
Okay, so can you give an example of that? Because I think some people will understand better with an example.
Sure. So if let's say I sue Lacey, I work for Lacey and I sue her over harassment of some type, right? If the lower court determines that the harassment occurred, right, and then Lacey takes it to the Supreme Court cannot disagree with that fact because that fact's been established. So they can't disagree with that. Then it's just a matter of, well, what's the question being asked? So the question typically when you ask the Supreme Court, they usually take up very specific points of law. Excuse me. And so the question, like Lacey would say, like in that case of harassment, would be, well, yeah, they determined it was harassment, but it was harassment to the point where I should be getting sued for it, or that I was violating his employment rights or something like that, right? So it would be a more specific question going in there. This is odd that the Supreme Court, they had two options. They could have taken the Republican Party's petition in Colorado, or they could take Donald Trump's petition. They took Trump's petition. Well, the Republican Party's petition had very specific questions of law that they wanted addressed, right? Which would have constrained the Supreme Court and the decision they could make. But instead, they took Trump's and they rejected the Republican Party's. So now it's a big open question. Did Colorado err in removing him from the ballot? So it's a big open question now that they can kind of answer however they want. So it's left it open. So let's see what he says. So this is Lawrence Tribe again. But let's see how he takes it. Because I think it's fascinating that they went this way. Because it's abnormal. It's not usual to do this.
Ramps. There are many approaches. What is interesting is that if you are a strict textualist, you really read the words of the 14th Amendment, Section 3.
14th
or
Amendment.
If you are a so-called originalist, a historian, someone like Jack Rakov of Stanford, a Pulitzer Prize-winning historian, leaves no doubt that the right answer would be the one that conservatives would give. It is more prudential moderates and liberals like Kagan and Jackson and Sotomayor who might wring their hands over the broad systemic impact on democracy. That's an ironic situation. It's filled with ironies. I mean, if you read the briefing submitted by Donald Trump and also by the Republicans of Colorado, it's filled with paeans of praise to democracy. The people should not be deprived of their vote. But Mr. Raffensperger, can't you just find me 11,180 of them? This is all about depriving the people of the right to end a presidency by engaging in what a detailed trial in Colorado concluded was insurrection. I don't think the court is likely to take a technical off-ramp. I don't think it's likely to hold, that the words of the oath that the president took to preserve, protect, and defend the Constitution didn't use the word support the Constitution, and therefore the president is not covered. I don't think they're going to take a kind of technical, highly legalistic approach. I think that the conservatives are going to have to establish that they mean what they say. And the one way they could do that is to say that although the original meaning of Section 3 of the 14th Amendment was that you didn't have to be tried or convicted of insurrection as long as there was a determination that you were an insurrectionist, Congress didn't need to create a special scheme to do that because people knew what the score was at the time of the Confederacy. But now you have to become a little bit of a living constitutionalist.
Right.
Decades have passed. Now things are different. Now there's a lot more controversy about the meaning of these terms. Now we need to wait for Congress to figure it all out and put a procedure in place that is more uniform nationwide. That would be a plausible decision, not one consistent with genuine textualism or originalism, but one that might make sense to the broad middle of the court. At the same time, they've got this very easy case about absolute presidential immunity, or whether the fact that he was on.
Yeah, he's going to go off. The immunity case is not going to float. I don't know that they're even going to take that one up. Because what ended up happening was his attorney argued, I think it was the DC Circuit or the DC Appeals Court. They argued about absolute immunity for the president. And one of the judges asked, so wait a minute, does that mean a president could assassinate his political rival and he'd have absolute immunity? And this attorney couldn't answer that question. Because that's essentially what they're arguing, is that he should have absolute immunity. Well, if that's the case, then Biden could have Trump killed tomorrow, and that would be legal.
Right.
Right? So it's one of these, well, yeah, he should have absolute immunity, but only this guy, not the other president, not the current president, just this former. See, it's such a labored argument. What he's pointing out is there's two arguments in the Supreme Court. And there's two views. The liberal justices, right, Kagan, and they tend to be more of this living constitution, right? They believe the Constitution can change and be altered. And that doesn't have to be, it's not necessarily, it has to be verbatim all the time, right? There can be interpretation. Now, that's more of a liberal kind of view, like, for example, you can say, well, look, just because, we had the right to bear arms. I mean, historically speaking, that wasn't always the case. Hey, the whole OK Corral fight was because they made it illegal to carry guns in town, which they could legally do back then. It wasn't until 2012 that the Supreme Court said, no, anybody should be able to carry a gun anywhere, right? So it comes to this sort of, it's a fluid sort of situation depending on what's happening, right? Well, now the problem is that the conservative justices, Thomas Alito, Roberts, and those guys, they don't believe that. They believe in, a more textual understanding of the Constitution, right? Well, in order for them to sit there and go, well, we're going to let Trump slide on this, they'd have to throw out the 13th Amendment and ignore the actual text, which is what his point was, is that puts them in a horrible position. And then they've got to side with basically the liberal view of a living constitution, which undercuts every decision they're going to make going forward and every decision they've made since they've been there. Because they've argued against that.
And watch them do it. Watch them do it.
Right. And the other thing is Neil Gorsuch, who's one of the Supreme Court justices, he was actually a justice in Colorado, and he's ruled on stuff like this before, for impeachments and things, and taking people off the ballot. And he's already ruled previously that in this sort of situation, like Trump's in, he shouldn't be allowed on the ballot. And now for a conservative justice to be in this position where Colorado, right, the state of Colorado is using his own judgments against him.
Oh no.
In the filing of the court. So his point
Lord, welcome to the shit show.
Right. So Mr. Tribe's point here is, I think what they're probably going to do is they took this vague sort of thing, and they can either rule it down or they can rule against Trump, which is the obvious answer, right? And there's plenty of contextual evidence to back that up, and the text is pretty literal on this. And you can't sit there and say, well, he has to be tried of insurrection, because insurrection wasn't a crime when they wrote the 13th Amendment. It hadn't been written down as a crime. So when they wrote it, everybody knew that, no, this wasn't because you had to commit the crime and be convicted of a crime. It was, the court just has to find that you committed insurrection. That's it. That's the only standard. So you can't run that case. So his whole thought is, what they'll probably do is they'll kick it to Congress and say, hey, you know what? We can't really decide on this. Congress is going to have to make a decision. You see how divided Congress is right now? There's no way they're going to be able to make a definitive decision on this. Not with a split Congress. And it could be really bad, because it looks like the Democrats might take the House again in 2024, which means you'll have a Democratic Senate and House making this decision. Right? But it's a way for the Supreme Court to kick the can out of their court. and just watch their hands at the whole situation.
And so they could kick it to Congress. Now, what would explain more clearly what allows them to do that?
The Supreme Court?
Yes.
Yeah, they can say...
What allows them to kick it to Congress?
Because only Congress can alter the Constitution or make a finding on the Constitution. So they can sit there and go, well, look, we can interpret the Constitution, but in this case, because it's non-specific, we're going to defer to Congress to make a more definitive statement about the 13th, this section of the 13th Amendment, or the 14th Amendment. Sorry. So they can sit there and go.
But they could be like, I don't know, it's not here. Well, it's not here. It's your job to put something here.
Right.
They could basically do that.
That we could interpret, right? So they could sit there and go, well, there's not enough here to really make a decision, so we're going to just defer it to Congress. My point is what are the odds Congress is going to come up with any sort of bill or ratification or anything that will solve this issue before the election?
Well, right now they can't get anything done.
Right. They might lose their speaker, which we'll cover here in just a second. But the thing about that is so now you're in a situation where they kick it to Congress. Well, it could take a year before Congress gets anything even remotely ready to pass. Right? So what does that do? It kicks it all back to the states to make their own decisions about how each state's going to handle it. But the Supreme Court gets to wash its hands of the whole thing and walk away without making a decision. What
do you think the odds are they actually do that?
I don't know. I think it's an interesting point that he's making, though, which is, I mean, what else are they going to do? The other thing they can do is they can either rule down the states, which really puts them in a bind, because now you're arguing a states' rights issue, and some of the states are going to revolt on that. right? Because you're taking away states' rights, which is the 10th Amendment, right? Anything not covered is deferred to the state, the individual states, right? So that's a big, sticky wicket to get in, right? That's a pickle and a half. So I doubt they're going to do that. And I think his point is really good. He's like, other than they could rule against Trump, but I don't think they want to, the conservatives are going to want to do that. Right? So what's their only option? Their option is, like we said last time, to find a way to weasel their way out of it. And what he's just pointed out is, here's a perfect way to weasel their way out of it. And the fact that they chose Trump's Supreme Court case over the Republican parties, they chose the vague one over the specific one, because on the specific one, they'd have to make a ruling. On the vague one, they could just go, well, it's too vague. So it's a little telling that they picked the one they picked, because it looks like that's going to be their off-ramp. That's what his point was. I think it's genius, but he could be right. He could be wrong. I don't know. We'll have to see. It's such a weird thing, but I think he's got a good point here where that's pretty telling that they picked that one over the other one. The fact that they did that tells you that they have some sort of strategy here that they want to play out. I mean, they're not slow, but
wow.
So we'll see how.
Okay.
So we'll see how it plays out.
We'll see how the next chapter goes on this one.
Yeah, but speaking about if it does get kicked back to Congress, well, Congress has got other problems. Well, at least the Republicans.